rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. Marching with a purpose, we're taking it higher. Fighting through the struggle, igniting the fire. No more silence, we'll make the noise loud. Together in this battle, standing strong and proud. Injustice fades when courage aligns. Rise up together, break the confines. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. So rise up now, it's our time to shine. Together we'll write a new paradigm. You paradigm, you paradigm. Whoa, whoa. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. Rise up now, it's our time to shine. United and free. We'll write a new paradigm, new paradigm. United and free. United and free. United and free.
State filed a notice of a probation revocation for the defendant as to his violation of the special condition within the sentence that he received from Judge Glanville on December 8th of 2023 as it relates to his reviewing, acknowledging that the factual acknowledgments that were a part of the plea agreement in which he entered into on December 8th of 2023. I have a certified copy of the conviction for your honor with a certified copy of the indictment, as well as a copy of the transcript of the plea that was taken on December 8th of 2023. An exhibit within that plea transcript is the plea agreement, which includes the sections, I believe it's sections 4 and sections 5 of the plea agreement as it relates to the factual acknowledgments that the defendant swore under oath during the plea that he had reviewed, then initialed each one of the factual acknowledgments, and then signed that he again understood and had reviewed each one of the acknowledgments that he initialed as part of the special conditions of his plea, that when called to testify, if called to testify, that the specific factual acknowledgments within the plea agreement were true and accurate statements, and that would be the testimony that he would provide as it relates to his witness testimony during the trial of this case. So I would present to the court State's Exhibits 1 and 2, as well as a USB drive of the defendant's testimony on day 124, 125, 126, and I think 127, Your Honor, but all of the defendant's testimony can be found on State's Exhibit 3. As everyone is aware, Your Honor witnessed it and can take judicial notice of everything that occurred during the testimony in which Mr. Sledge did testify. And I believe the court during, I think it was day 125, helped direct the defendant to sections 4 and 5 of the plea agreement during the testimony for him to focus on and read and to go one by one and acknowledge or disavow is the only word I can really think as to being no longer true and testifying under oath that he was violating the special conditions of his probation, Your Honor. So this time I would tender State's Exhibits 1, 2, and 3 for the court.
All right, I'm not quite sure I understand what 3 is.
3 is a USB drive with all of the testimony of the defendant. If Your Honor wants to preview it or wants to be part of the record.
Is that from the official transcript?
Well, it's the YouTube link, the live stream of all of the...
Okay, I'll just take judicial notice of it. I mean, if you want to make an exhibit, that's fine, but I'm not going to be relying on that.
So,
Since, as you know, it's only the official transcript that is the official transcript anyway, but I was here and witnessed it, so I will take judicial notice of it.
yes, and I'm very much aware of that. The transcript obviously is not ready as we're still in the midst of the trial.
Right.
I didn't want to overwhelm the court reporter who has been doing nothing but probably working hardest out of everyone in the courtroom. So I knew Your Honor
All right.
either could take judicial notice
Thank
or
you.
rewatch it. Can I approach it?
You may. And can you try to use a mic, please?
Yes, Your Honor.
Can they go to the court reporter?
Nothing further from the state at this time, Your Honor.
All right. Mr. Wright,
Your Honor, may I remain seated or?
it's probably easy, you can. It's probably easier to hear you that way.
Okay, I think I'm on. Your Honor, if it'll please the court, I believe, and I already sent to the court defendants 1 through 6. Defendants 1 through 5, I believe, were already, I think my emails between myself and Ms. Love came into evidence during our testimony.
Came into evidence in the trial of the defendants that are on trial right now.
Yes, Your Honor.
Yes.
So those are sort of resubmissions
Okay.
of those, but I do think they're already before the court, or the court can potentially take judicial notice of that.
What is your Exhibit 6? I think I
Well,
only got 5.
Exhibit 6 is the one thing, and that's just a listing of my emails in December between
Oh,
myself
that's
and Ms.
this one
Love.
page?
Yes.
Okay, it didn't have an exhibit marker on it.
I'm sorry,
so
Judge.
that's fine.
So succinctly, I thought it best to submit these exhibits. When you look at Exhibits 1,
And
2,
those are admitted for purposes of this record, which is the probation revocation matter.
Thank you, Judge. When you look at Exhibits 1 and 2, what you see going on is plea negotiations in this case started on December 27th between myself and Ms. Love. You can see it's in the evening hours, and that's one reason I wanted to make sure that the sort of cover page along with the attachment are part of these exhibits. At approximately 4:57 p.m. is when the email first comes in from Ms. Love. You see that a second one, Defendants 2, comes in at 5:06 p.m. And at some point I respond. Those are the only 2 exhibits or the 2 drafts which occur on the 27th. However, it's important to note that when you see the response that I send to the email at 5:06, I send that response at 8:42. And I point out specific issues with the draft that need to be revised.
Right. Yeah,
Now-
and I recall we discussed this during the trial of this, the ongoing trial as well.
Yes, Your Honor. And the point I won't belabor it is these revisions, you actually see being put into the drafts. So by the time you see defendants 3 and defendants 4, they note that there's attachments updated to. You see that those very revisions that we requested are being put into the actual drafts. And ultimately, it was Defendant's Exhibit 4 that if you look on Defendant 6, when the email comes in, it says, use this one. That is the agreement that we thought we were executing on the 28th. And remind you, on the 28th, we're in court. This isn't where I'm at my office, I can print it out, look at it, take it to the client like we did on the 27th. On the 28th.
On the 28th, both you and Mr. Sledge are in person in this courthouse, right?
Correct. So the emails, if you notice, I never respond because I'm here, I'm in person.
Right.
So we would get it and via phone, or if they would give me a draft, you know, to take to him, I would literally go from the conference room back to the holding area. We would go through it, go over it. But the one that we thought was going to be the executed final was the same one that they said on Defendants 4, use this one.
Are you testifying now, or are you just recalling for me the testimony from previously during this ongoing trial?
I am asking the court to take judicial notice.
I will take judicial notice of what both you and Mr. Sledge testified to in the trial. I recall it.
Understood. So, ultimately, the last thing that I think we mentioned in our testimony was where we did take issue with some things. We said he'll have a chance to answer the question and to explain. Now, there was a big problem, and I noted in my testimony that number 8 on that version that got signed had been taken out, removed. All of a sudden it reappears and it's there. My client initialed it. Yes, it was tendered. But ultimately, here's the problem. My client has always said he does not know who's responsible for shooting the victim, who he never was a participant or heard about planning the murder of the victim, and therefore number 8 was put into evidence by Ms. Love to the court when it was a knowing statement. She knew that that statement was false. That is,
I'm not sure about that. That may be your contention, but
well, we would contend to the court that where my actual email Defendants 2 clearly denoted that.
it does not. It is up for debate what that denotes.
It is removed from all the drafts and then ends up back in.
That is true.
So.
But your response on your Defendant's Exhibit 2 to what is then item number 4 does not definitively state anything like what you just said. He said he did not know, as we discussed at the time of the ongoing trial, could have been interpreted in several different ways. But I understand what you're saying.
And just so
You maintain that the two of you both missed the fact that you signed, or your client signed, a factual acknowledgement that included item number 8.
correct.
And then when Ms. Love read it out orally in the court, and Mr. Sledge, one by one, said, yes, I acknowledge that somehow that didn't occur to you at that point in time either. So I understand what the assertion is. Here's the thing. You seem to be focused almost wholly, if not wholly, on, well, maybe there was a mistake with regard to factual assertion number 8. The issue that I see is that the state has not limited their petition to revoke probation to he contradicted or he refused to acknowledge during the trial that item number 8. It is the entirety of disavowing factual acknowledgments, et cetera. And What got disavowed under oath in this trial was far more than just item number 8. It was item number 3, item number 4, item number 5, item number 6, item number 7, item number 8, item number 9, item number 16, and then the part 5, sentencing acknowledgments, number 1, number 2, number 3, number 4, number 5, number 6, and the paragraph underneath asserting that he's read and that they're true and that he understands that he's had an opportunity to discuss it and he voluntarily enters into it, et cetera, et cetera. So even if we entirely disregard item number 8 of the factual acknowledgments, there are still however many other ones that added up to that the state is still relying upon. And I don't see how you get around, and maybe you have a way to get around the rest of it, and I'm certainly willing to listen, but that one thing is sworn to in open court on December 28th of 2022, and then something diametrically opposite of that is sworn to under oath back on September 5th of this year.
I understand your concerns, Judge. One of the things that we traveled on after taking the plea was he would be able to explain his answers if he had issues.
Can I ask you a question about that? Is there anywhere in the guilty plea agreement in sentencing of your client in December of 2022 where you reserve that, where anybody, the state, the defense, or the court puts on the record that that's part of the understanding?
It is not in the written plea agreement, no.
All right.
However, in evaluating my client for the purpose of this hearing, I don't think the state is denying that that is something that it was understood, understanding it's not in the written plea agreement, but it was understood. And the other thing to also take note of, my client, when asked to make himself available, to meet with the state, to be prepared by the state, at all times would show up and do that. He was never provided or questioned it with any details such as, here, let's go over your plea agreement, these factual allegations, what questions may be asked. In other words, what you saw at trial was someone who was now, after what was that, December of 22, was now for the first time being drilled or questions rather as to the specifics of all the things that he had allocated, all the questions that were going to be asked. There was no preparation of him. So what you saw was probably frustration on his part at times and shutting down at times on his part. But it was also part of the manifestation of what happens when a witness who's not a lawyer, who's not someone used to this, is getting questions fired at them. And at some point, I think the court can take note that he literally shut down. And some of what the court saw may be more of a manifestation of being overwhelmed as opposed to trying to purposely change or diametrically say something different than what ultimately he allocated initially. So I, in retrospect, wish the state had actually, more than general questions, actually prepped him like you would normally see a witness be prepared and prepped. That did not happen. So you saw a very raw witness recounting things that happened quite some time ago and did not necessarily say things consistent with what he said before. But it wasn't simply for a malicious intent or an intent to deceive. There are several factors, is all I'm indicating, that may well explain why it was so difficult during his testimony.
All right, anything else you want to present?
Your Honor, not at this time, no.
All right. Can the state give me a quick rundown of what this defendant's prior history is, including any prior probation violations? And then I guess I know that the probation officer is on here, so I'd probably need to at some point ask that officer if they would like to be heard as well.
And Your Honor, we would defer to probation as it relates to, I know they have a full account of his history as
All
it
right,
relates to.
you know what, I think I'm still on Zoom.
Yes, Judge.
Yeah. And what's the officer's name?
That's Jolly.
Oh, it's my regular probation officer from long ago, whom I haven't seen in the last 2.5 months because I've been otherwise occupied.
Hello, Judge Whitaker.
Hello, I'm trying to, oops. Okay, I'm trying to get myself on video. I know. So that it's not a disembodied voice. Hang on. All right. Hello, Officer Jolly.
Hello, Judge.
All right, what is probation's, can you give me a rundown of Mr. Sledge's criminal history? And I'm sure you heard the question I just asked, as well as any prior probation violations.
Well, currently, he'd used his first offender twice, one for DeKalb County, one for Fulton County.
Well, that's lucky.
The DeKalb,
Since you're only supposed to get to use it once, okay.
yes, so the DeKalb County case, 04CR24799, that was theft by receiving stolen property, felon, and a obstruction of law enforcement officer, which was a misdemeanor. That was May 19th, 2005. I'm sorry.
Okay.
He used his first offender. The second case, 04SC23883, that's Fulton County. He used his first offender. That was possession of cocaine, as well as a possession with the intent to distribute cocaine. That was December 10th, 2004. The possession with intent to distribute cocaine in Fulton County was January 3rd, 2014. Again, both times, all three times, he used his first offender. The next case is 15SC138994. That is a Fulton County case. That is the gang participation, aggravated sex battery, attempted aggravated sex battery, aggravated battery, aggravated assault, criminal damage first degree, criminal damage second degree, and possession with a firearm by a convicted felon. That was January 10th, 2018.
All right, so given the fact that he had at that point a possession of a firearm by a convicted felon, does that indicate that at least one of those first offenders was not successfully completed?
One
Or are we
moment.
missing a felony?
One moment.
He was adjudicated guilty.
That would be correct, Your Honor. In addition, of course, the current case that he is currently on probation on. As far as previous revocations,
So, hang on, so the 15 SC and then this 22 SC case, right? Is there anything
Correct.
between the two of them?
there's nothing in between the two of them, no.
Okay. Are you looking about prior revocations or prior violations?
Yes, at this present time, I don't see any prior revocations. There was one documentation. It's a little bit, I guess, I'm having a hard time understanding what they meant by it. One moment.
Judge, while she's pulling that up, there is a 13 SC 123423 out of Fulton County. It's a VGCSA, possession of cocaine with the intent to distribute, where the defendant received 5 years probation on January 7th of 2014, which would be the predicate or basis for the possession of a firearm by a convicted felon of the 15
I
SC.
figured there had to be something else there. Okay,
Sorry, I should have spoken sooner. I apologize.
appreciate it.
Yeah, the only documentation that I have regarding a revocation just said revoke closed July 16, 2008. Doesn't really show any actual time served or any time being revoked or continued on probation back in 2008.
Okay.
So I'm unsure if that's an actual revocation that was completed.
Okay, well, yeah, it sounds like maybe it was revoked, but it was just wrapped up in something else is how I would take that. I don't know, but, or that that a violation was found, but we don't know what that was or anything like that. All right, so does probation have a recommendation in this case?
Due to the last minute notification of this probation revocation, I would leave that up to the courts to make that decision.
Okay. All right, well, I find there to have been a violation as alleged, and again, even discounting the item number 8. What is the state's recommendation?
In full candor to the court, Your Honor, I'm going to leave it, the state is going to leave it in the full discretion of the court. Your Honor is fully aware of the conditions. Your Honor witnessed the testimony and how it affected the trial of the case, and I'm going to let Your Honor be the full steward of deciding what the penalty should be as it relates to all of the time that Mr. Sledge still has remaining on probation.
All right, well, I know that at least, I believe in the petition for revocation, the request is that the entire 30 years be revoked, is that right?
It's not the
Or
request.
is, oh, you're just telling me that's what he has at this point, although it can't be all of it, right? I mean, he's been on probation for at least a couple of years, and did he serve it? What's left?
He just started on December 8th of 2023. I think he got credit for the time. I think he was in for 2 years, so he would have 26 and change or 25 and change.
I'm sorry, correct, 22.
My bad.
The exact number. That would be 27 years, 7 months, and 8 days.
All right. All right, thank you. Anything else from either side?
No, Your Honor, nothing further from the state.
Okay.
Your Honor, if it'll please the court, I understand the court's ruling that there is a violation. Ultimately, I guess to some degree, while it's not clearly akin to a substantive versus technical violation of probation, it is a non-violent, non-new offense kind of violation, and I would say if the court is going to violate my client, it would be more germane to treat it as a technical violation. We have expressed to the court different thoughts and reasons for the way the testimony came out. We don't know what effect, if any, one way good or one way bad, that is had. But in terms of his violation, I would ask the court treat it more as a technical. He has one grandchild on the way, one that just came early this year with Ms. Jaquila Freeman. So the point is, he has been staying out of the way. He's been complying with probation. I would ask the court to maybe consider if you want to put more restrictions and make his probation much more of a, not just something he's on, but something that now has more teeth to it because he's been working. He's been taking care of his family. He's staying out of trouble. He's turned that corner. And literally, it was always our hope he wouldn't have to come in and testify. And there was a reason the state allowed this plea to go forward so that he could step away. And in doing so, if you recall, you may have remember from his testimony, by no fault of his, he was a victim of a crime where he was shot multiple times and had to recover from that. So we would ask the court to consider some restrictions first as opposed to custody. And if you do go with custody, we would ask to consider it as a technical type of violation, not a substantive violation in which you would be authorized to give him an even greater sentence. So we would leave it in the discretion of the court, but we're asking again for a non-custodial revocation punishment.
Okay, well, I don't view it as a technical violation or akin to a technical violation, considering the solemn oath that he took when he said that he understood every term within the plea agreement, factual acknowledgments, and sentencing acknowledgments, and understood and, in fact, orally answered that he understood when both asked by the prosecutor and the court at his plea hearing that a failure to abide by any of the terms would constitute a violation of the agreement, and he was notified that the entirety of his probation could be revoked. I do appreciate the fact that this particular violation is a non-violent violation. But I also appreciate the fact that some of the many why this could have occurred include the fact that there is just not a proper regard for the judicial system and the seriousness with which an oath in court needs to be taken. I actually view this much more akin to perjury, frankly, than a technical violation. And the sentence for perjury is up to 10 years. I am going to revoke 5 years of Mr. Sledge's probation. And Mr. Sledge, I am sympathetic to the fact that you have generally stayed out of trouble, and I want to commend you for that. And I really hope that this revocation doesn't set you back. But we've got to take seriously the court system. So that's the sentence of the court. I find there to have been that violation. I'm revoking 5 years.
And
And he
reinstating
will be
the balance.
continued on probation, Your Honor?
Yeah, and reinstate the balance.
Your Honor,
Thank you.
might I ask, is it possible for my client to turn himself in to make arrangements?
I think y'all knew when you came in here that this was a strong possibility. So, no, I'm sorry. All right, court is adjourned.
The system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. Marching with a purpose, we're taking it higher. Fighting through the struggle, igniting the fire. No more silence, we'll make the noise loud. Together in this battle, standing strong and proud. Injustice fades when courage aligns. Rise up together, break the confines. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. So rise up now, it's our time to shine. Together we'll write a new paradigm. You paradigm, you paradigm. Whoa, whoa.